Hello, everybody. Welcome back. This is Deirdre Virvo. Thank you for joining us on Let's Talk Live. On Let's Talk Seniors, memory care issues, Parkinson's, dementia, and Alzheimer's. We are bringing you every day, Monday through Thursday, some exciting experts in the field of seniors giving all different topics. Tonight is no exception. We have a fabulous attorney, Michelle Beltrano, and she's going to be talking about what it costs to die in Connecticut. We all know how expensive it is to live in Connecticut. It is also pretty expensive to die here if you do not have a plan. Before Michelle comes on, I think a lot of you know that I opened Just Like Home, a senior assisted living home in Shelton this week. And I gave some tours today. It was so exciting. I love it. The house looks beautiful. It's ready for people to move in, or even for your seniors that want some respite care. So if you're going on vacation and your parents are living with you and you're thinking like, what do I do with them? I can't go anywhere. You know, we are open to take them for a few weeks, even for respite care. They could try it out, see if they like it, see if they're comfortable. And I'm sure they will be. If they want to stay, they could stay, or they could just come for a little vacation, mini vacation from you, or if you're away. So I would love to show you around, and I'd love to give you a tour. Also wrote the book, Home to Home, the step-by-step senior housing guide, and I've been giving them out right and left. They sell on Amazon, but if you want a copy, just email me right there, dvirvo@gmail, and I'm super happy to send you a copy to anybody that would like one. So without further ado, we are going to welcome Michelle Beltrano. I'm going to tell you a little bit about her. Fabulous lawyer. She is the principal and owner of Beltrano Law, which is a boutique firm located in Greenwich, but she serves all of Fairfield County, Westchester. And she does estate planning, trust, and estate administration, elder law, and probate matters. Her firm provides concierge services so that all individuals can have access to estate planning services no matter where they're living. Michelle holds degrees in both nursing and in law, which enables her to bring that combined experience and understanding to her clients. She speaks frequently in the community, is also on the board of At Home in Greenwich, an organization that offers programs and services which allow older adults to remain independent and stay in their own home. She is dedicated not just to her practice and what she does, but she's also dedicated to seniors. So without further ado, Michelle Beltrano, welcome again. So nice to have you.
Hi, Deirdre. How are you?
Great. I see it's a sunny day over there at your house.
Yes, it is. I'm trying to avoid the sun, but I love the sun, so I'm glad to see it today.
Right? I'm teasing you. So you were telling me the other day how expensive it is to die intestate or without a will in the state of Connecticut. So why don't you give us a little bit of background for people that don't know you about your firm, what you do, what you specialize in, and what you love to do?
Well, we really have the mission here to try to help people. In a nutshell, we try to help people plan ahead and save money in the future. And by that, what does that really mean? I mean really to try to help them plan ahead so that for the long term, they can have the quality of life that they would like to have, that if anything happens where they cannot control every aspect of their own life, that they have people that they trust to do that for them. And then also that they understand and can mitigate any of the costs of when they pass away or when you die. You know, it does cost money to transfer your assets to your loved ones. And you always want to make sure that you're able to transfer those assets so that you give your loved ones or your beneficiaries of your estate the legal title, the clear and free and legal title to your assets. And you want to make sure you do that as inexpensively as possible. And you want to make sure that you have control over how that is done and how it's distributed. So that's where we come in. We do planning for while you're alive, all the way up through and through your estate administration process.
That sounds like a long process.
It can be. I mean, we look at it, it's a little more simpler. Well, it's really not. I mean, I think both while you're living to make a plan is so important, because you want to also save money, and you also want to make sure that your wishes are carried through the way you want, and that you get to live the life the way you want. In order to do that, unfortunately, a lot of us and our friends and family are afflicted with some sort of chronic condition that can, it can basically develop symptoms that would, impede or impair your ability to physically do things or mentally do things. And so, we look at that, and, really, even if you have a diagnosis of a chronic condition that does impair your memory or your ability to cognitively process something, we can still work with you at different phases of your illness, and we can kind of ascertain how, what you are able to talk about, what you are able to choose. Most people are able to express, where they want to live. They express who they want to be around. They can express, who they want to give any of their assets to. They usually know their family. Ideally, that's when they can still come into us and do some planning. Certainly, there's some very sad, unfortunate cases where they're no longer able to do that. If they do become unable to express themselves at all, of course, then it's much more challenging. So I always say, plan while you can, and it's not always too late. You can still check and see if you can do some planning to try to save money for your long-term care planning while you're alive, and then also for your estate administration process for after you die.
Is there an age you suggest people start this plan?
Well, I think, certainly by the time you're 50, I mean, you should start to think about, the rest of your life. And, maybe you have children by then, maybe you don't. Maybe you have a business. Maybe you have, a house or two, or own land or something like that. And you have to think about, if something happened to you, how would those different assets be distributed, and where would they go? Certainly we don't want your assets to end up in the hands of someone that you don't know, a distant cousin or something like that. So by documenting your wishes in your legal documents, you can certainly try to avoid any unexpected transfers to people, and any unexpected and costly consequences.
So tell us, if you are alone, not married at the time, what does it cost to die if you have assets that you did not properly handle or assign or designate or put in a trust or have a will? What happens if you die without a will?
Well, I think, first of all, it's important to know that even if you die without a will, that you can, your loved ones can apply to the court. Someone would need to apply to be an administrator of your estate. And then they would be able to be authorized to be able to handle the transactions that are necessary in order to distribute out your assets. If there's no will, and if you, let's say you never were married and you don't have any children, and let's say, you were a teacher at Juilliard and you had a great passion for music, and you had a baby grand piano in your living room, and you owned a beautiful house in Darien. If you didn't specify, or, you didn't sign your will and really specify where those assets would go to, they would go to your heirs at law. Which, if you had siblings, it could go to your siblings. If you had parents, it would go to your parents. But then after that, it would start to go to nieces and nephews. And if you don't have any of those, then it would have to go to cousins. And that could be really complicated. And it could end up going to someone in California that you never really knew very well, or you maybe didn't know them at all. So that's why it's so important to try to see, would you have rather said, oh, I'd like my money to go to a foundation for a scholarship, for a music scholarship or something like that. So there's always ways that you can plan.
And Michelle, is that how it goes? If you die, does it first go to your siblings, your money, and then if they're not there, your parents? Is that the order it goes in?
Well, first it would go to your spouse if you have no children. If you don't have a spouse and you have children, then it would go to your children. If you have a spouse and children, part of it would go to your spouse and part of it would go to your and then it would go on from there. So it would go to, if you don't have parents and don't have children, then it could go to siblings. So it's, there are people, we have many, many clients that really don't have anyone. There's a lot of single people out there, and they shouldn't have to, pay so much for the administration and have their money go where they don't want it to go. So, there's certainly a lot of options and choices out there.
Do you also get any tax benefits to endow something or to leave your money to someone? Is there a benefit to doing that tax-wise?
Yeah, there are different. There's different types of charitable trusts and so forth, where you can use the money during your lifetime, and then you can leave it to a charitable organization, which can often have some tax mitigation there as well. It really depends. I think the most important thing that I would say that everyone needs to be aware of, whether you have a will or not, is that you would have to pay statutory probate fees when you die on your total gross estate after deductions. And so that can range between $25 and $40,000, depending on the size of your estate. And it is a sliding scale. So it's a surprise because Connecticut doesn't call it a tax, but it certainly acts like a tax and looks like a tax and seems
What
like
do they call it?
They call it statutory probate fees. And
okay, so
really
if you're married?
It's yes, even if you're married, it doesn't matter. There's no exemption to the statutory probate fees, unfortunately. So
if you're married, Michelle, and I guess it depends on how you have things deeded, but you have to pay this, I'm writing everything down here, statutory probate fee on like half the house you own or half the properties you own together?
Basically, it depends on how the house is titled. So if the house is, it depends whether it's tenants with right of survivorship or if it's tenants in common, right? So there's a huge set of scenarios, different scenarios that could occur depending on how the house is titled. But let's say a decedent died and they had a will, and their house was their husband already died and they're a widow, right? And basically now their house, was left to them by their husband, of course, but now the house needs to go somewhere after the spouse dies. So where does she want it to go? If she wants it to go to her 3 children, what is the best way to do that? And so the house, any life insurance policies, any IRAs, retirement plans, any brokerage accounts that have transfer on death beneficiaries, any joint accounts, anything like that will be included in what's called the gross estate. And I look at it like a fried egg. So your fried egg with the white and the yolk of it is the total gross estate. The yolk is just the assets that pass through probate. The tax return that you're required to do in Connecticut looks at the total gross estate. So it looks at the whole egg. And then the statutory probate fees are based off of what is in the entire egg. So even if you leave your children a life insurance policy of $1 million, and you, even if you have a house that is being left to someone else as a joint owner with right of survivorship. So let's say you have your daughter on the house with you, and the house automatically by law will go to your daughter, but that house will be counted in your, 50% of it will be counted in your gross estate. And the $1 million of life insurance will be counted in your gross estate. If you have an IRA and you are leaving it to 2 children, that whole IRA will be counted in your gross estate. And
is there anything exempt, or is there a way to exempt these things?
Well, what you would want to do is, number one, when you do your estate planning and you speak to your estate attorney, you want to make sure that they get all the information about all of your assets, including any assets that have beneficiaries on them. And then what you can do is you can determine if there's a way to put any of those assets into an irrevocable trust. An irrevocable trust, depending on what type it is and when and how it works, it could be basically it can take assets out of your total gross estate, and so that when you die it would not be included in your total gross estate. For example, I had a client that put her house in Greenwich in an irrevocable trust years ago, and the house, increased in value. And by the time she passed away, it was worth like $2.5 million. Now, had that actually been included in her total gross estate, it would have raised her up to the level where she had more probate fees and she had a taxable estate. So by not having this house, which was worth $2.5 million, in her total gross estate, by having it in an irrevocable trust, she was able to lower her tax liability and her statutory probate fee liability.
So I don't think that a lot of people realize that they have to do, even if you're married, you have to do a final tax return. And I guess this is why. Is this why you have to do a final tax return when you pass away?
The point is that Connecticut wants to see what your total gross estate is so they can give you that invoice for the statutory probate fees.
Nice. That's a nice gift when you pass away. That's so sweet of them. But anyway, so I buy a lot of houses to flip from elderly people where somebody might have passed away 10 years ago, the husband or wife, and they think because they own half the house, they could just sell it. But it turns out so often they've never done that final tax return. So they've never actually gone through the whole, they're like, well, this is all we had, the house and whatever, some money. So we didn't, and they didn't go through any of that. So now before they could sell, they have to do this.
Yeah. And there's 2 benefits to that, Deirdre. One thing that people forget, and that is so, so important and valuable, is that when the first spouse dies, and you do that tax return and you pay those statutory probate fees, you get a step up in basis. So if the house was purchased in 1960 for $40,000, but the spouse died in the year 2000 and the house was worth $300,000, they get a step up in basis to that $300,000. Then in 2020, if the second spouse dies, they again get another step up in basis before they either sell the house so they don't have any capital gains, or if they were to actually give it to a child and devise it to them, that child could receive it at the stepped up basis of value without paying gains on it. So
that's great. So that's another reason to do it.
Good thing about these tax returns and the statutory probate fees is that you're recording on the record that, yes, we are paying these fees, we're getting a step up in basis. And after you pay your statutory probate fees, you get what's called a release of lien. And there's 2 types. There's a release of lien on your house, on your property, but you can also get just a release of lien for the estate saying that you paid all of your statutory probate fees and you have clear title to that house.
And is it a percentage? Is it a big amount of money?
Well, what I did was I jotted down a couple examples because I feel like that's always better to kind of understand. Like I said, it's a sliding scale. It ranges from $25 up to $40,000. But if your gross estate, including your house, your life insurance, your joint accounts, if it is approximately $750,000, you pay $2,490 in statutory probate fees. And you don't have any estate taxes to pay, but you still have to file that tax return to get that release of lien, right? And then if your estate is $1 million, the probate fees go up to $3,115. But then if your gross estate is $11.8 million, your probate fees would be $40,000. And then you would have to pay federal and state taxes as well for any amount over the 11.58 million, which is the federal deduction amount for this year.
$11,580.
Yes. So per person. So, and for the federal, tax exemption amount, it's actually portable. So when one spouse dies, if they don't use the whole 11.58 million, they can save whatever portion they don't use. And then when the second spouse dies, they can also use it.
So is this a calculation that every accountant, CPA knows about?
They do.
Mm-hmm. And so on top of the tax, you have to pay your accountant to do your final tax return.
Right, exactly. And people get very, very, very upset when they find out that we have to file documents with the court anyway. You have to pay people to prepare those documents, to prepare the tax return. So therefore, that's where your costs come in. If you can mitigate the process down from, let's say, 25 steps, mitigate it and shorten it down to 5 steps, your cost is going to be much, much, much less. And if you also do some other more complex planning, depending on your estate, you might be able to really lower the probate fee cost and make sure that your estate is not taxable when you die. That's the other key thing.
So that's where you come into play.
Right, exactly. And the other examples I just wanted to share too was that, for example, if your estate is $4 million right now in Connecticut, you would not have to pay any taxes. But if your estate is $6 million, you would have to end up paying $90,000 in Connecticut estate taxes, plus you would still pay the, I can't remember if it would be 40,000. I think the 40,000 in for the statutory probate fees. So,
this is different than the statutory and probate.
Right, right.
What is this one?
This one is the Connecticut estate tax.
So on top of the probate fee, you have to pay an estate tax?
If your estate is worth more, your gross estate is worth more than 5.1 million in the year 2020.
So if it's worth like 6 million, like you said, that's 90,000 on top of the is there some sort of sliding scale between the probate? Because you said 1 million was only $3,100, and then
let me see here.
11 million was 40,000. It seemed like quite a jump.
Okay, yeah. So 11 million is definitely 40,000. But if it were 6 million, let's say it was 6 million, the statutory probate fees would be $5,615 plus 0.5% of all the in excess of $2 million. So it's a very, I can't memorize the sliding scale of the probate fees, but it there is a probate fee calculator, which is on the probate court website, which is www.ctprobate.gov, which is excellent, and it kind of gives you an idea. But so you would have the probate fees, which would be that. And then in addition, if you're 6 million, you would have to pay taxes on anything over the exempt amount, which is 5.1 million. So you would be paying taxes on $900,000. And that would be, the rate is essentially 10 to 12%, depending on the amount. So if
that's a lot.
Mm-hmm. Yes.
That's a lot.
where I calculated the $90,000 of Connecticut estate taxes was because anything over 5.1 million, you
Right.
would have to pay 10% of the excess over the 5.1 million. So that
So,
would be,
Michelle, when you make people's plans, are those the kind of key numbers that you're keeping in mind? Like you might say, if you have 10 million, let's make sure we keep it under 5 million so that we're not paying any estate tax, and then keep it under, like, are those like the key numbers that if you don't want to put everything in your estate, you have to at least protect anything over 5 million?
yes, I mean, it depends. Every case is so extremely different, but yes, and you have to see if they're single or if they have a spouse, and where they're at in the whole thing. So it really depends. But certainly that is the number that we look at and we say, oh, if they're over that number this year. But see, the issue is that it changes every year. And we obviously don't know if and when anyone's going
Right.
to come, right? So it's kind of like figuring out like 4 different scenarios or if they died. And we also just add the language for tax mitigation and tax planning in the document, no matter what their estate is, unless it's a very, very small estate. So let's say if they had $3 million, we don't know if that $3 million is going to grow, like, right? Like maybe
Sure.
their broker's doing a fabulous job for them and their assets that they bought are appreciating very nicely. And so, and in that case, we say, you know what, even though you're not a taxable estate right now, we would want to add in that special language in your will, in your trust, or figure out some other tools for you, and make sure that you have it just in case you need to use the tax mitigation strategies
So,
later.
Michelle, do you ever have people come to you that are totally in the dark and they have, $5-10 million and they just didn't have any plan in place and didn't have an accountant telling them or anybody helping them, and
Well,
they're just like hit with a giant tax bill? Is that
most
common?
people, yeah, I mean, that has happened, but I would say that most people know, they just have put off planning. Um,
Oh.
and
So
they,
they know what they should be doing, they just didn't do it yet, or they died younger than they thought and they just didn't
right,
prepare properly.
yes,
So they
yes.
knew about it, they just yeah, I could see that being the case, right? Like,
Yeah, and certainly, some people die horribly unexpected, which is very sad, and and that can really impact things. But most people that have that kind of wealth either inherited that wealth and they already have planning within their family, or they are business people. And most business people know that you need to have certain amount of plan and tax planning. And so we work very closely with our accountants, and they're all of their team, to make sure. With sometimes financial planners, sometimes brokers, we have to determine what's best to do. A lot of I have clients of all different ranges, of all different sizes of estates, and really, no matter what your estate is, I say it's always less expensive if you plan now than if you don't either plan later or when it's too late, or you don't plan at all. So that's why planning is really a cost-saving tool. And, we try to work with individuals to make it as painless as possible and as quick as possible. But it's some estate planning does take a little while, and some can be done in a very quick amount of time.
I'm just thinking that I remember when my father-in-law died like 35 years ago, my mother-in-law ran to the bank, pulled out all their money, and then called us to tell us he died because they thought they were going to freeze her assets.
Yeah.
And Michelle, let me tell you that she had $3,000 in the bank.
Yeah.
I'm pretty sure they weren't going to freeze her assets, but that's what she was thinking. So
Yes.
that was her estate plan.
Well, it depends if it was joint or not. But if it was, let's say you have a sister, like let's say I had a sister that I'm caring for, and she has Alzheimer's, and she's got some other health issues like diabetes and things like that. I'm caring for her. And although my name is on her bank accounts as her power of attorney, I am not a beneficiary of her account. Her children are, but I just happen to be helping her with her finances. So at the point that she dies, if she does not have a plan, her assets would be frozen, and my power of attorney authority would no longer be valid. It's not valid after someone dies. So her assets would be frozen in the bank. And if we needed to still pay for anything to care for her, or depending on whether she was living at home or in a nursing community or assisted living or at a residential care home, it really depends. And so you want to make sure to think about those things with your planner to figure out what's the best way so that you have the liquid to pay for anything that you may need to pay for.
So you touched upon two pretty big expenses. You have to basically pay an accountant to do your last tax bill. You have to pay this statutory probate fee, and possibly pay an estate tax over a certain amount. Are there other things that you need to pay?
There's other costs to getting a valuation of your assets. So basically, the process in the probate court is that you need to file your original will with a petition to the court asking them to admit the will to probate. And that allows the executor to receive their fiduciary certificates. Once that's accepted into court and you get the decree, you are the fiduciary there. And there's the different fees associated with, the will filing and that sort of thing. There's other fees then. So let's say if you owned a certain painting that was worth $500,000, you would need to determine the value as of your date of death, and your executor would have to get a valuation of that or an appraisal. We often also have to get appraisals of homes, businesses, cars, other assets,
jewelry, boats,
jewelry, things like that. Now, there's certain items that, it depends. If they're not insured, you don't always necessarily have to get a valuation or appraisal of them. So it really depends. And I think it's important to kind of know and let your estate planner know what type of assets you do have ahead of time so you can kind of plan. Sometimes the best thing to do is to give those valuable actual tangible property that's very valuable, to actually give it to your beneficiaries before you die. Sometimes it can be a lot less expensive and a lot less red tape, but it depends. So, and one thing I just wanted to add, a lot of attorneys and a lot of law firms that do estate planning, they also do the estate tax returns. So we do the estate tax returns for some of our estates. It depends, but I work with a lot of tax accountants that deal with more complex estate tax returns, just so you know.
So I know that you love when people come to you, Michelle, to plan and make a plan, and you're all about saving them money and making sure everything gets to where they want it to go and passed down to who they want it to go to, and that it all gets there safely. But if a spouse passes away without a plan, you'll also take on these clients to help them mitigate their last, whatever they have to do.
Right.
To figure that out.
Yeah. We have some clients that did do the right planning. And when they come to me, we say, are there any assets that are outside of your trust that are that are not going to pass through the trust? And in those instances, we can say that there's very little to do. It depends on whether it's the first spouse to die or the second spouse to die. It depends on whether they're single, and whether they had a revocable trust plan as well, or an irrevocable trust. It really all depends on what they did. Some people do plans with other attorneys years ago, and then they come to me, but they've never been to me before until that time when they pass away, or their loved one or their spouse passes away. And so, we deal with all types of clients at different stages, and we basically just gather the information so that we can figure out the best and the quickest way to proceed for you.
Are there other fees?
Trying to remember. There's definitely, fees for accountants, fees for attorneys. There's fees for the probate court. There's
Fees for
potential
appraisals, fees for
Mhm.
asset appraisals, filing fees, things like
Filing
this. So it's
Yes.
what if somebody can't afford all these fees?
Well, that's the thing. It depends on how many assets, what type of assets, and how many assets, and what their total estate is valued at. That's something that, it really depends. Generally, if someone has a smaller estate, they generally don't have a lot of complicated various types of assets. So then it can be a little less costly. Certainly, Connecticut does have the option of what's called filing a small estate. So if it's less than $40,000, you can do this small estate procedure, and you can eliminate a lot of the steps as well.
So let's say you had a parent that sold their house already and maybe be in assisted living, or somebody that's just living on Social Security. They could file what's called a smaller estate and have a much simpler, easier, quicker final return and everything.
Yes, exactly. Yeah, and that's the great thing is that.
And Michelle, is this something that is in every state, or is Connecticut different than other states?
Well, I think Connecticut is definitely one of the most expensive states to die in. I know I don't have the exact citation of the article, but I know Forbes did an article a couple years ago and talked about that. Certainly, a lot of our clients from Connecticut are leaving the state, and I think even New York as well, going to less costly states such as Florida. Florida does not have any estate tax, and they don't have any statutory probate fees. So, there's planning around it. If you love Connecticut and you love New England and you want to be here, there's certainly ways to plan around it. And
what if you were living, what if you were a snowbird and you were in Connecticut half the year and in Florida half the year? Would you have to be living in Florida like 6 months and a day to consider that your residence to have no estate tax? Or
yeah, what I do is I always check with my accountant, because they usually are familiar with the current tax laws and what the requirements are per state. Like each state might have a different requirement, but generally it's the registration to vote, the driver's license, actually having a doctor in the place where you would like to be residing and domiciled in. So if you want to be domiciled in Connecticut, you should have, physicians here that you see. You should receive mail here. You should have a bank account here, and you should vote here, and register your cars here and that sort of thing. So you have to think about that vice versa. If you want to live here 6 months out of the year and live somewhere else the rest of the year, if you want that to be your primary residence, then you need to think about those factors too.
I mean, does it make sense that if you're a snowbird and you live half and half to go to Florida, for instance, if you have a home there, and register everything there?
So say that, I'm sorry, Deirdre, we just cut out a little bit. What did you say?
Would it make sense if you are, for instance, a snowbird that has a home? I think my parents, they're from New York, and when I grew up, I thought it was a requirement for grandparents to move to Florida at a certain age. I just, like, if some grandparent didn't, my grandparents did. If some grandparent didn't go, I was like, what happened?
Oh, I know.
So if you are living there as a snowbird, for instance, and, let's say you have children up in Connecticut and you're living in Florida half and half, or whatever it is, whatever the split is, would it behoove you to just register everything you just said, to vote, your car, get a doctor, get a bank account and everything in Florida? So, you can claim that as, the state of your residence. So you avoid a lot of tax.
I mean, it could, Deirdre. I never like to give a blanket statement about anyone, because I've never found, two exact cases exactly the same. So, but I think that's, something that you would have to really discuss with your estate planning attorney, discuss with your accountant, discuss with your spouse or your partner, and see, what would be best to do. How can you save money? So that would be a great option.
Seems worthwhile just to buy a house in Florida for that reason.
Mm-hmm. Mm-hmm. Certainly, many people do. I think we both know quite a few people that have, and they have not regretted it despite the hurricanes. So
yeah. Hurricane shutters seem to cost less than, this estate tax stuff up here. It's crazy.
Yeah.
Wow. Michelle, you really shed a lot of light on this. I didn't know a lot of it, and I hope this helped a lot of our viewers. And the key to it all is planning.
Yes.
That seems to be the key to everything.
And the other key I just wanted to say also, Deirdre, is that if you have a change in your life and you are moving to Florida, or if you are purchasing a business or a different house, additional property, or if you are remarrying someone and you have biological children and now you have stepchildren and things like that, it's always great if there's any change in your life that you touch base with your estate planner regarding that change, and just review your plan just to make sure that it is tight and secure and protects you and helps you save money in whatever your new situation may be.
Makes sense. So don't leave out your estate planner.
Right.
Tell them any times a change in your life and invite them to your next wedding, and just make sure it's all good.
Right.
Thank you so much, Michelle. That was so informative. Oh my gosh, I had no idea. I knew that people did not file the final tax return because I've come across it umpteen times.
Yes,
and
definitely in real estate, I'm sure you have seen the problems
all the time.
Mm-hmm. It's fascinating.
We have to quiet titles because their mom was on the title and she died 20 years ago, or a spouse died and they just assumed that everything got inherited to the surviving spouse.
Right.
People are always in shock.
Yeah, it's
and
really
then they're shocked that it costs money.
I know. It's really sad, and I hate breaking the news to tell them what it is we have to do, and it's always much easier to swallow the news if you do it right away versus 10,
or if you're prepared for it.
Yeah,
it's also like funeral planning, right? That's pretty expensive too. So if you're prepared for everything, it's way better than leaving it on the shoulders of your children or your spouse that could be elderly to try to figure out what's happening.
Exactly. Yes.
Well, Miss Attorney Michelle Beltrano, it's been a pleasure. Thank you so much for talking to us here and enlightening us seniors on everything going on and us regular folk. I really appreciate it, and we hope you'll come back on the show. You come back and tell us you're just a wealth of information. How do you just retain all this stuff?
Yeah.
So much.
And
it changes all the time.
It's always changing, and we're always, trying to keep up on it all. And certainly, thank you so much for having me. And I really enjoy talking to you and to your guests and to everyone in the community. It's a lot of fun.
You are welcome. Well, we will see you again. Thank you so much, and have a great night.
You too.
Bye, Michelle.
Thank you.
Wow, Michelle is so informative and sweet, and she's so knowledgeable, but also isn't it interesting that she was a nurse before? So she brings that whole thing to the party, caring for people and knowing all about the legal part and knowing what she's doing. Love her. Thank you so much, Michelle. All right, well, we're signing off. It's just like home. Thank you for tuning in to Let's Talk Seniors. Until tomorrow. Hi, Deirdre here again. Thank you for joining me on Let's Talk Seniors Memory Care Issues. Is this an issue hitting home? Do you have a parent or loved one with memory care issues who you feel is not safe at home anymore? Are isolation, falls, and safety issues becoming a big concern? Welcome to Dogwood Senior Home, premier boutique residential senior living specializing in memory care. It's country living at its best in the Huntington section of Shelton, Connecticut. We're truly a home with only 6 senior residents living as one family unit. Senior residential homes are concepts sweeping the nation with 47,000 across the U.S. We're pleased to open Dogwood Senior Home as it will be only number 6 for Connecticut. Brand new, sparkling clean, opening mid-June. And safe, safe, safe. We are COVID-free. Residential care homes boast a very low COVID infection rate across the nation. This is due to the intimacy of size and speed in which the caretakers can shift to accommodate immediate needs. They are much safer than the large homes and facilities, as you can imagine. It has been documented that residents have less falls and a better quality of life in a residential home environment. Our home is more affordable than the big box facility. You pay one all-inclusive price, and that price is guaranteed for the life of the resident. With an incredible 1-to-3 caregiver ratio, which you won't find anywhere else. Our friendly, loving caregivers are dedicated and trained in Alzheimer's, dementia, and Parkinson's issues. We're only taking 6 residents, so the home will fill up fast. Call me at 203-689-7562 for a talk and tour. I would love to meet you and your loved one. See you soon. Bye.